Thank you all for being patient. This is our week 1 question and answer session. Folks have submitted questions. I have quite a few of them, so I'm going to go ahead and go over them. If we have time, I will also take additional questions. Before we get started, are there any procedural questions? Okay, I see none, I believe. So let's go ahead and move forward. That didn't work as planned. Hold on just a second. Megan, you can ask questions by typing them in the chat box. That would probably be the best way to do it because I'm not sure I can see your hands being raised. All right. For some reason, my slides don't want to progress. Oh, here we go. All right, so first I got some procedural questions, so let's chat about those. Okay. Ms. Padilla, our tech specialist, has told me that sometimes there is a delay with the PowerPoint moving. Apparently a significant delay. There we go. Okay, general question is for expectations in the answers that I'm expecting. Am I looking for lengthy paragraphs with details from the cases like quotes for most of the questions, or am I just looking for your thought process, even if it's shorter, as long as you put in the effort? So I am looking for thoughtful answers. The length of your answer is really going to depend on the question. References to cases may be appropriate. If you do make them, you don't have to do them formally. You can just refer to the case name. The same with quotes or paraphrases. They may be appropriate. You can paraphrase the court, I think is probably a better way to do it, but you can stick in quotes as well if you need to. I'm looking to see that you spend a little bit of time on these and not just quickly breezed through them, because let's talk about the purpose of them. The purpose of them is you are to pretend as if we are in class and you are on call and I am asking you those questions. So answer them as you would if I had asked you those questions in class and you were on call. The benefit of doing it this way is that everybody gets a chance to engage in the topic every time, as opposed to having one person doing it, and the stakes are a bit lower. They're not in front of everybody, etc. So if you keep that purpose in mind, I think you can use that as your guiding point. But generally, I'm just looking for some effort, because a large part of class is usually not me lecturing, but me asking you questions, and that's an effort to try to mimic that. Okay, the next question. Boy, this is really a problem with these animations and PowerPoint slides and WebEx. It looks like no platform is immune from these technological difficulties. All right, well, I have a question in front of me, so we'll just go with that. The second question was, is there a place where we can go and review submitted answers, model answers that you posted, and video? And the answer is yes. What you do is you go into Edpuzzle and you click on the video that you would like to look at the questions and answers for. And you should be able to view, I confirmed with Share RTA, you can view the questions, your answers, and the model answers. So that should answer that question. Let's see. I'm going to try something a little bit different. I want to see if I share my screen with you, perhaps. Let's see if this works a little bit. Yeah, okay. I'll just share my screen with you so you can see the PowerPoint. All right. Could you speak a little bit about the crossover between property and tort law? In the cases we've read so far, I see many places where the two intersect, and I'm wondering how much tort law you would like to see in any analysis of a property question that we do. That's a great question. So let me explain why there is so much tort law in these questions. Well, there are two ways to enforce property rights. One is by seeking criminal charges if there is a crime, like a trespass crime. The second is to initiate civil proceedings and to initiate litigation. And if you go the civil route, which is where most of the cases, if not all of them, that we read are going to involve some civil suits, you need to state a claim. So claims can either be contractual claims, which are claims based on contracts. They can be statutory claims, which are claims based on statutory rights, or they can be common law claims, right? And many of these common law claims are considered torts as well. So you do not need to apply tort law that you learned outside of this class to the questions in this class. But if we talk about a tort like nuisance, for example, which is a tort, then you will need to know it to the extent that I present the material in the class. Okay. Does anybody need any further clarification on that question? I've lost the chat bubble, so okay. I don't see any questions in the chat. Great. Okay, let's discuss the right to transfer a little bit. There were some questions about the right to transfer. So when we were talking about the right to transfer, remember the right to transfer is one of the rights in the bundle of sticks that we call property rights. What we're often trying to figure out is if the owner has the right to transfer or we call alienate the property. And to do that, we can look at the way that the property is titled, which is something we're going to look at in future chapters. But we can also look at other restrictions there might be to transfer. So the cases that are presented in this chapter in the latter category, they're looking about restrictions on transfer that are not related to necessarily the way that the property is titled. More so, there might be statutory restrictions, zoning ordinances, or public policy reasons why we may restrict transfer in certain situations. So the cases, Johns v. McIntosh and Moore v. University of California, they look at what the restrictions are on the right to transfer. What could they look like? So it's not an effort to try to enumerate all of the possible restrictions on property. They're just two examples of types of restrictions there can be on transfer. And we're going to explore some more exceptions in future classes. The second thing that these cases show us is what the justifications are for restrictions on the right to transfer. So it takes kind of a broader picture. We're discussing conceptually, theoretically, how can we justify these restrictions to the right to transfer if we say that we believe in the owner being able to do as she sees fit with the property. If that's where we start, then how are we justifying restrictions on the right to transfer? Okay, so to what extent, I have a question here, to what extent do we need to incorporate the cases we've learned into our essay responses? So I think it's important to note the fact pattern. So when you talk about essay responses, do you mean on an exam or in the questions that you're getting as your participation questions? Because I think you're going to need to reference the cases, and I think it's good to be able. Okay, mostly on the exams. All right, great. So you won't. So the exams are going to be open book. I think I can tell you guys that now. They're going to be open book because they're remote. So you will have the ability to refer back to the cases to try to remember which case was what, but they're good examples to use to support your arguments in your exams. Yes. But we will also have elements and be relying on the restatements of property. So I think to answer that, to the extent that the restatements on property are silent, then I would look to case law. But if you have a restatement that is on point, you can just cite the restatement. We haven't really gone over restatement rules yet. All right. So the question was for Macintosh, could you go over the policy arguments that are not made very clear? Specifically, it seems that most of the policy arguments can be inferred or being inferred. And I noticed that a lot of your video questions focus on public policy. And I'm wondering if you have any tips to really focus on the public policy arguments. Okay. So first, I just wanted to address why we have focused on policy arguments for this chapter. Many of the cases that you read in this chapter were seminal cases that created or established a right that was not previously found in case law. Or it was a case that changed the understanding of a right. And so when courts justify their opinions, oftentimes they point to precedents or they point to the language of the statute. Well, if there is not a statute on point, which is the case, a lot of the cases with property law, you'll see there may not be a statute on point. So if there's no precedence, there's no case law, and there's no statute on point, then the court needs to justify why they are making the decision that they make. And to do that, they make public policy arguments or arguments that are supported in reasons that deal with benefiting the public or emphasizing a particular social good. You can think of policy arguments as those arguments that are not based on statutes or the case law. So that's a pretty good dirty trick to figure out if something is a policy argument or not, because the court isn't going to explicitly say, I'm going to make a public policy argument here, right? But what they will do is they'll make arguments that are not based in previous case law, that don't refer specifically to the statute, and you can intuit that those are public policy arguments. So what I'd like you to do is to grab your book and let's turn to Johnson v. McIntosh. Because the next question, there we go. Or maybe that was the previous question. There was a question about the public policy issues in Macintosh, so I wanted to go over them with you. So we look at the case. Let's turn to page 30. And let's look at the second paragraph, the last sentence. So here, the court is saying that discovery gave title to the government by whose subject or by whose authority it was made against all European governments, which title might be consummated by possession. This sentence ends a paragraph that argues or justifies why conquering other countries gives governments the justification or the ability to gain title to land. As you can see, there's no reference to statute here. There is no reference to previous case law. They are making a statement that that is the way that title is achieved when you have a nation conquering another nation. Okay. So if you go to page 31, third full paragraph starts out with, our whole country has been granted by the crown while in the occupations of the Indians. Okay. And then turn to page 32. What is that? The second full paragraph that begins, the United States then have unequivocally acceded to that great broad rule by which its civilized inhabitants now hold this country. Turn to page 34, third paragraph, third sentence after the semicolon. If a country has been acquired and held under it, if the property of the great mass of the community originates in it, it becomes the law of the land and cannot be questioned. Okay, all of those sentences go to the court's building or argument that most of the citizens in the United States at this point had acquired their land title through this means. That's a public policy argument, right? Taking away those land rights would then cause, they don't explicitly, I don't think they explicitly say this, but taking away those land rights would cause chaos. So you can find the public policy argument by looking and seeing what the court is arguing. And here the court is arguing that typically in situations when a country conquers another country, this is how a title of land is acquired. And this is how most citizens in this country have acquired their land. And so that's one example. Sometimes you have to read through the case and then put together the argument. Let's see. They make another argument that starts on page 33 when they're trying to justify. Well, first of all, they say that assimilation is preferred. So it's preferred that when the conquering nation comes and conquers, the people then just assimilate into the dominant nation that conquered, and that dominant nation then absorbs them. But they argue that the character and habits of the Native Americans make it so that assimilation is not possible. But they make another public policy consideration, and they say that where incorporation is practicable, humanity demands, so there's a public policy argument, humanity, right? And a wise policy requires that the rights of the conquered people should remain unimpaired, that the new subjects should be governed as equitably as the old. So these are some examples of some public policy arguments and how he pulled them out. But basically, you're looking for justifications that aren't statutes or previous case law. Does that answer the question, or do you need any more clarification? Okay. This next question is whether or not this concept of discovery still holds today. Most of the land in the world has already been discovered and accounted for. In the US, that is particularly true. If new land were, the only examples I could think of were, let's say a new island pops up off the coast of South Carolina, for example. That would be the only other place I could see some type of law of discovery applying, but then nobody lives there, so because of the island popped up. Another example, which again, this would violate treaties, but let's say the US were to try to go and conquer another planet, and the planet had some type of living organism there, then this would apply. This law would apply to that situation. Now, again, it would violate a bunch of treaties if we started going conquering planets, but the United States doesn't always care about violating treaties, so it is within the realm of possibilities. Okay, the next question was, there was, in the points for discussion after the McIntosh case, it asked why Native American right to transfer was relevant 50 years later. Okay, I attempted to put together a chain of title for this case. It doesn't look very pretty, but bear with me. So the reason it's important is, although Native Americans transferred the land 50 years before the case at hand, there's something called a chain of title. And the chain of title traces how the property passed in a sequential way. And it has consequences on future land ownership. We're going to go over this again in detail a bit later. However, let's see how, yeah, this really is not pretty, but work with me here. Okay, so the Native Americans had property, all right? They deeded part of that property to a group that became, by really two, it should have two prongs. They did two transfers, one in 1770. Can you all see my mouse, or no? Do I need to use a pointer? See if I can use. Oh, you can see it. Oh, great. Lovely. We don't have to mess with any of this other stuff. Oh, right, because I shared my screen so you could see me moving all the boxes. It was very inconvenient, by the way. We're going to have to figure out another workaround. Okay, so there actually here should be two prongs because there were two land transfers, one in 1773 and one in 1775. And they were two separate owners. Let me look at my notes. I just called them Investor Group A and Investor Group B. They later merged and became Johnson et al. And so that is why we have this Johnson et al. Case. So here the Native Americans deeded the property to Johnson et al. In 1773 and 1775. Parts of the property. Now, There's another chain of title over here that happened earlier, I guess, right? So if we go by the discovery doctrine, this land was discovered by Cabot, which made it belong to England in 1498 under the doctrine of discovery, because they were the original conquerors, who then ceded it to the United States in 1776 by treaty and other transfer rights. Okay. Then the United States sold it in 1881 to Macintosh. So that was by a deed directly from the US. So why does what happens 50 years earlier matter? Well, when we look at chains of title, we often go by first in time rules. So what happened here, they think they're owners of this property. So that can hinder the ownership rights of Macintosh over here. So that's why it matters. More. So there was a question about the Moore case and the idea of utilitarianism. If it's based on the idea that decisions should be made to do the most good for the greatest number of people, then wouldn't more cells and research being done with them be considered the greater good for society? Yes, that is the case. And that's the argument the court is making, right? So the court is arguing that the greatest good for society would be to allow researchers, to encourage researchers to do the research, which means to allow them to excise the cells and do their research, create products from the cells, and then sell the cells. I'm sorry, sell the product, which is a cell line. So yes, they are making the utilitarian argument there. But then the question asks, extending this logic out further, it seems that we have murky waters of martyrdom. When do you stop asking people to make personal sacrifices for the greater good, and at what cost? So that is the question with utilitarianism. And I have a great video of a professor of ethics who poses a series of questions about, if we apply the theory of utilitarianism, then do you sacrifice? How far do you go on? And I'm going to share that video with all you also. You can watch it and see, and that this is a very valid point, which is why philosophers came up with other theories. Utilitarianism often espouses a balancing act too. So I think at some point they would say that making too many personal sacrifices is not for the greater good. It's more than just a numbers game. So you kind of have to say, well, is it good for society if everybody's organs are game for being taken out? Well, at some point it no longer becomes the greater good. So it really is a balancing act, but it is not a clear or bright line test. Okay, question 3 on Moore. What is the legal distinction between somebody selling of a replenishable body part versus an irreplaceable one? It's a very good question. And the legal distinction is statutory. So there are state laws, and you can see the ones in California, which are on page 40 of your book, the different statutory codes. And then there's also the Uniform Anatomical Gift Act on page 41. It references it. And those acts and statutes make the distinction. That's the legal distinction. So what's the justification for the distinction? That's another question entirely. I suspect the justification has to do with the risk to the individual, with the idea being if you sell replenishable parts, it's less risky for the individual's health than it would be for selling non-replenishable parts. The procedures that you undergo in most cases, but not all cases, are relative, less risk than those that would be, for example, required to transfer an organ or remove an organ. So those are the public policy justifications for the laws, but the laws or the legal distinction are statutory based. And that is where we as a society have decided to draw the line, for better or for worse. That seems to be the common consensus. All right. Do we have any more questions on Moore or McIntosh? If not, otherwise I'm going to move to the right to exclude. All right, let's see. Would it be possible to share our answers publicly to the questions of whether or not we think people should sell their body parts? I would love to see other people's thoughts. I am happy to host a discussion thread where you all can discuss this question. That way people can choose whether or not they want to share their thoughts. Okay. Any other questions? Seeing none. Can we discuss? Maybe I should close this thing. Hold on. Yep, I don't know how to do that. Put that over there. Okay. Trespass. Can we discuss the issue of trespass further? Can we discuss? Oh, sorry. Copied and pasted that twice. So the issue of transfer or trespass. Trespass is a tort. It's also a crime. But its purpose is to protect the landowner's right to exclude people from their property. You can think of trespass simply as being the intentional entering of the land of another without their consent. Trespass does not require, there's no damage requirement there. The simple intentional act of entering the land of another without their consent is sufficient to meet the elements of trespass. And trespass is an example of the positivist legal approach to property rights, which is that if we don't have a civil claim or a criminal charge for trespass, then the right to exclude would not be a right, because it only exists so much so as is possible. It only exists as much as the government enforces it. So these laws, the purpose of laws are to encourage or to deter people from enacting in certain behaviors. And this law does that through punishment. So the idea is that we could protect the right to exclude if we punish folks for violating it. More questions on trespass? All right, could we go over the stated test set out in State v. Shed? Sure, why not? Now, I think hopefully I made it clear in the questions that I asked that the court avoided constitutional arguments, even landlord-tenant law, in this decision. And arguably, this was because the court wanted to limit the precedential value of this case. So they made a very narrow ruling, And that ruling, let's find it. Let's find it together. Let's go to page 64. Now, the standard set out in Shack may have been difficult for you all to find because it includes multiple statements. It's not just one line. What you have to do actually is derive it from the court statements on page 64. So the first part of the standard, sorry, Teddy wanted to interject himself into our lecture tonight. The first part of the standard can be found in the last line of the first paragraph on page 64. So too, the migrant worker must be allowed to receive visitors there for his own choice, so long as there is no behavior hurtful to others, and members of the press may not be denied reasonable access to workers who do not object to seeing them. All right, so that's one part of the standard. If you have a migrant worker, they must be allowed to receive visitors. But that right to receive visitors is balanced by the rights of the owner. And so their behavior can't be hurtful to the landowner. All right. Then we go to the second paragraph, last sentence. We have the court adding on to the standard. They say the employer may regulate their entry or bar them, at least if the employer's purpose is not to gain a commercial advantage for himself, or if the regulation does not deprive migrant workers of practical access to things that he needs. That's another component of the standard. The employer may regulate or bar entry if we want to add it to the standard above, if there is harmful behavior, or really for any other reason, as long as that reason is not to gain commercial advantage of himself, and as long as that reason does not bar the migrant worker from receiving access to things that he needs. You see, the test gets a little bit complicated and murky. And then the third part of the standard, we go to the next paragraph, second sentence. You may reasonably require a visitor to identify himself and also to state his general purpose if the migrant worker has not already informed him that the visitor is expected. So that's another part of the standard, is that he can ask for the visitor to identify himself. I would say that was the standard. I think people had a hard time finding it because you had to build it from reading that entire page. So it was a little complicated. All right, exceptions for the right to exclude that went into State v. Shack. The exceptions in State v. Shack are based on a statute or the idea of a statute. So the court's rationale was that the right to exclude of the owner was interfering with the implementation of a federal statute. That is really what the court's rationale was. The lawyer and the person that worked for the nonprofit that was seeing to somebody's health needs, both of them worked for federally funded nonprofits. And it was based on a statute, a federal statute that was enacted in order to help migrant workers. And the idea was that the right to exclude could not interfere with this implementation. It also was justified by the last page 64, second to last paragraph, last line. These rights are too fundamental to be denied on the basis of an interest in real property and too fragile to be left to the unequal bargaining strength of the party. So what does that tell us? What is the exception then? Well, you can argue that the exception only applies to migrant workers. You can also argue that the court was saying generally when we are dealing with, so the court was saying, we're going to balance the rights of the landowners with the rights of the non-landowners. And the interest in real property, which is the landowner's interest, did not outweigh the interests of the migrant workers. It means more of a case-by-case analysis. It's a balancing test where you look at the owner's interests versus the user of the land's interests. We also talk about another exception called necessity. Necessity feeds into this balancing test. It says that we're going to balance the needs of the public and balance the needs of the third party versus that of the owner. And folks may enter the land if it is sufficiently necessary, right? We're going to go over more exceptions as the course goes on. These are just the first few. So you don't need to worry about having a laundry list right now of all the exceptions to the right to exclude. So we're going to revisit this topic. Any other questions? All right. The next question. So the question was about for rural undeveloped land, absent no trespassing sign, hunters have an implied right to enter, but hikers do not. Does this derive from a safety concern? Are there other reasons behind it? Well, there are other reasons behind it. There are other reasons why the exception was worded that way in the first place, and then there are a different set of reasons as to why it still continues to be in place. So let's first explore why that distinction was made in the first place. I did a little bit of research, and looks like these laws were created in the 18th and 19th century. And at that time in the US, there was large amounts of undeveloped land, and people subsisted off of, they lived off of the land, and hunting was a way by which people fed their families. And because hunting fed families, these laws were put in play, and land was undeveloped. There were no privacy there weren't as many privacy concerns as there are now. And the hunter's right to enter seemed like a legitimate right. I don't know. Research would have to be conducted, and I've been told it's very hard to find case law from the 1800s and the early 1900s. But research would have to be conducted on whether or not there was ever a conversation at this point as to whether or not hikers should be included. Now, why do we still not allow hikers? It probably has to do in part with fear of damage to the land and fear of legal liability from the hikers tripping on parts of a property. In the US, we have um, a litigious population in theory, theoretically, and we have some rules that are pretty, some slip and fall rules, for example, that ways you may remember from your tort class to hold a landowner responsible for injuries that occur on the property. And I suspect our long history of supporting those types of claims has made it so that the idea that we would allow hikers to enter onto land that we owned is unlikely. Now, I was watching Ragnarok on Netflix, a very reputable source, and it was actually interesting because it is set. Oh, I'm blanking on where it's set right now. Iceland, Norway, maybe Norway. Anybody feel free to chime in if they've watched Ragnarok. But well, they live in a Scandinavian country, and the right to roam came up in the show because they wanted to go hiking on this land that was owned by the rich family in the town. And there was an interchange of dialogue between the main character and the owner of the land. And he said, I want to go hiking. And he said, well, that's our property. Well, the main character is saying, yeah, but what about the freedom to roam? And the owner said, that's fine, but just remember, you're taking on your own risk. So there are ways in which to allow that. I say this to say that there are ways that other countries have allowed for the right to roam by still protecting the landowner from liability. And one of those ways is by restricting or allowing it so the landowner is not liable. So unclear as to why that's not a discussion, aside from maybe we think of it as not American. My dog Teddy has brought the lion. He feels that you all need to see the lion right now. I don't know why. So here you go, Teddy. Thank you. We have shown everybody the lion. All right. Back to property. Okay. The gambling hypo on page 65. I was surprised by that. There's Teddy with his line. Come on, Teddy. Again. Sorry, guys. He's a puppy. So the question about gambling establishments, I was actually surprised by that answer as well. I am from Las Vegas, and so I have seen many of the TV shows, primarily CSI Las Vegas, where people were excluded from, and we've all seen the movies where people were excluded from property because hotels because they were counting cards, right? So I don't know what the laws are in most jurisdictions. I haven't had any time to do anything, much less research this question, unfortunately. However, I did have a little bit of background on what. So it looks like the New Jersey Supreme Court just held that when property owners open their premises to the general public in pursuit of their own property interests, they have no right to exclude people unreasonably. And it looks like in applying the unreasonableness standard, those courts felt that it was unreasonable to exclude this person because they were a card counter. So do I think that the majority of jurisdictions would act in this way? Probably not. I would suspect if I looked at case law in Nevada that it would be different. All right, Teddy, here you go. Say hi. Hello, mommy's property class. How's everybody doing? Okay. There we go. He's our therapy dog, so he'll be the class therapy dog. Yes, he's the cutest piece of personal property that one could ever own. All right. Let's see. He has brought me all of his toys, and they're all at my feet right now. All right. So hopefully I answer that question. Maybe one day I'll look into it because I think it is kind of fascinating. All right, Teddy, you're going back. Go back to play. Property creation. Yes, he will be our property mascot, Ted. Okay, I have a question regarding the creation of property in the modern era. We have a lot of video content that's being spread by different media. And how would that work as far as claiming ownership over it if the video distribution mediums were to try and claim the content? Very good question. So we actually, Professor Levine teaches an IP class. I would recommend that you take that class where he discusses all of this. But suffice it to say, it is a brave new world when it comes to media content. So the way that copyrights work, we're not going to go over intellectual property in this class, but here's your brief 2-minute intellectual property. So when you create a piece of work and you publish it, you would do by publishing it on the internet or putting it on Instagram or Twitter, you have created your copyright in that work. So now then you come to the distribution of it. Well, what is distribution? Well, sharing across social media, you would have to show that they made money off of that. So when it comes to a distribution platform making money off of that video, then you have a right. Now, it's unclear to me. Yeah, I don't know. I would have to ask Professor Levine about whether there have been any cases about just retweeting or resharing copyrighted material. I suspect that you should always give an attribution to the artist, to the correct artist. I have a guest speaker on Monday. I have to edit the video. I will be posting it, and she's talking about artists' rights in visual media. However, it only covers in the US, only paintings and so forth are covered, not videos. But that's a great question for Professor Levine, and I hate to punt it, but aside from knowing that a copyright has been created when it's posted, and that if money is then earned based on the resharing of it, then money would be owed to the copyright holder. All right. Yes, Teddy is actually not left. He's sitting on my feet. So he wants to join again, but he has to sit down and learn to behave. All right. Move the line again so I can see the book. As the right to roam made its way into American judicial systems for consideration, as I did a very quick and dirty search before for this Q&A session, and I did not find it. Now we know that Britain has recently revisited this and has recreated the right to roam, because the difference is the right to roam at one point existed in Britain and it exists in Scotland. So in the US, to my knowledge, it has never really existed here aside from all right, let's try that again. So to my knowledge, it has not existed in the US aside from that right to roam for hunters. And I haven't heard anything about any jurisdictions. So some arguments against the fact that we would ever have a right to roam is we have a lot of parks and national parks, and so people can go there. I don't know. I'm sorry, I don't have any. What on earth? Okay, was that the right? Oh, I guess that was the... All right, that was the last question. That's why. Sometimes it's not the technology and it's the user. Correct. Oh, and look at that. It is almost exactly, we have 2 more minutes. Almost exactly 1 hour. So that worked out well. Does anybody have any questions before we adjourn? I'm happy to take some. At this point, you can raise your hands and talk too. I can facilitate that because I can look at the participant list. So if you know how to raise your hand on this platform, feel free to do that too. I see no questions. All right. Well, that is it for today's Q&A session. Stay tuned for next week, where we will have another Q&A session, as well as a guest speaker and a bunch of very fun and exciting videos with questions, and perhaps maybe even a social gathering. Who knows? All right. You all have a wonderful day. And of course, you can always schedule an appointment with me. There is the link somewhere. It's on our website in the syllabus. I can make it available to you again, though. Feel free to schedule a meeting. All right. Take care, everybody. Have a great weekend.